So that is a landmark case, and it was the first time that the Second Amendment was incorporated or applied. They used the 14th Amendment to apply it?
Well, that's the case that comes in 2010. That's McDonald v. Chicago, which incorporates. So here's how the modern Second Amendment case law looks. The first federal court to hold that the Second Amendment protects an individual right in clear and unambiguous terms happens in a case, United States versus Emerson, which is a case from Texas. And that deals with the provision of the Violence Against Women Act, which says if you're under a domestic violence restraining order, you can't be in possession of a firearm. Why anyone would argue that if you're under a domestic violence restraining order, you should be in possession of a firearm still kind of baffles me. I suppose the argument would be, well, you still need your right of self-defense, so even if you've under a restraining order, maybe, I mean, again, it's hard for me to know that if you're dangerous enough to be under a restraining order, why you should have a gun. But anyway, the argument went to court, and the court said, yes, it's an individual right, but clearly the government has an interest in protecting people, and if some administrative agency or court has decided that someone is a threat and they've issued a restraining order, then it's not unreasonable to say, you have to give up your gun. So that was decided around 2001, I think. The next case was, of course, United District of Columbia v. Heller, which dealt with the District of Columbia's very, very stringent gun control law that dated from the 60s, an era of great turbulence in places like Washington. And there the Supreme Court said that the Second Amendment was an individual right, and it was an individual right tied to self-defense. And it's a case that is curious. It's a case that politicians across the spectrum have embraced and academics across the spectrum have attacked. It clearly has supporters among gun rights people and some supporters of originalism, but what's amazing is a number of very conservative jurists, J. Harvey Wilkinson and Richard Posner and Charles Freed, Harvard Law School professor, have all attacked as being judicial activism, except pro-gun rights judicial activism. And conservatives for years had been sort of against judicial activism, and the criticism now was, now that the court had gone conservative, that they had to, now that their hands were in the cookie jar, it was okay to, disregard the idea of restraint, judicial restraint. So it's a 5-4 decision, but what's interesting is even the liberals argue about what the history meant. So it's an originalist decision. There are two originalist opinions, two versions of the originalist history, Scalia's version and Justice Stevens. And then there's a Breyer decision, which uses some history, but is more about prudentialism, which is, balancing social costs. So, and since that case, we've had 600 cases at the lower courts. Almost all of them have upheld the law. So it's been very good for gun lawyers. It's generated a lot of litigation, but it hasn't changed the facts on the ground because the District of Columbia's law was so much an outlier that anything that could pass the political process in America, which for the last 20 years, at least until Newtown, was fairly pro-gun rights, not fairly pro-gun regulation, anything that could have gotten passed in the last 20 years would have been constitutionally acceptable because it wouldn't have passed otherwise. So there hasn't, the law was a great interest to academics and has produced a lot of good, interesting scholarship, but it hasn't really changed things very much. So I guess as a professor, it's good for me, but it hasn't really made much of an impact. Then 2 years later, the law was applied to everywhere because the original case dealt with District of Columbia, which is this odd federal entity. Now it's applicable everywhere through the incorporation principle that you mentioned.
Well, may we understand our history and solve our problems too?
I think that history can actually show us that it's okay to regulate firearms and you won't lose your liberty, and I think that's a message a lot of people need to hear.
Well, thank you very much.
Thank you so much for having me.